Hi, everyone. Welcome to our final event for the Center of Latin American Studies lecture series, Charla con Café. For those of you, could you please turn off your audio? There's a couple of you with audio, and actually we for the first portion of today. It would be best if everyone turn off their video except for the panel participants, just to reduce bandwidth issues during the presentation. So welcome again. For those of you that don't know me, my name is Stephanie Grader. I'm a core faculty member in the Center for Latin American Studies, and I'm very happy to be introducing, as I said, our final event of the year, which is a particularly exciting one and another wonderful opportunity for us to engage with scholars at a greater distance and open up our conversation to both to a global audience, really. So I will, as you are probably aware, today's event is called Protection of Nature and a New Constitution for Chile, Lessons of the Public Trust Doctrine. This event was put together by our own Carl Bauer, who is a professor in the School of Geography and also an affiliate faculty with the Center for Latin American Studies. He works in the field of comparative water law and policy and has been studying law and political economy of Chile's constitution and water code since 1990. And often engages in public policy and academic debates in Chile as well. And so he's brought to speak with us today, Matías. I talked with him about how to pronounce his last name, and then I immediately lost it. So Matías Guiloff. Who teaches administrative law at Diego Portales University Law School. In the past, he has also taught several courses concerning environmental law, natural resources regulation, and constitutional regulation of the environment. His main research interest concerns how law deals with the tension between stability and change and the role that property rights play in the management of such a tension in areas such as water rights regulation, land use regulation, and environmental law. We also have with us Dominique Hervé, who teaches environmental law at Diego Portales University Law School. In the past, she has worked at the National Commission of the Environment and at the Environmental Enforcement Agency in Chile. Her research interests include environmental enforcement, environmental justice, and legal issues related to climate change. So I'm going to go ahead and pass the screen off to Professor Bauer, who will give us an introduction to the event more deeply and get us going. So thank you everyone for being here.
Thank you so much, Stephanie. Thanks to everybody. Thanks to the Center for Latin American Studies for the invitation and the opportunity to talk with you, a fairly diverse audience as far as I can tell from my little black boxes on the screen. Let me just share PowerPoint here. This is the title of our report and also of our panel today, Protection of Nature in a New Constitution for Chile, Lessons of the Public Trust Doctrine. I want to say that both Matías and Dominique are here as two of, well, the three of us are here as 3 of 8 co-authors. And it just so happens that our calendar allowed us to be here. Our other co-authors, some of whom are present virtually, are just as important as we are. And I also wanted to just remind anybody who needs the reminder of geographically where the country of Chile is on the southwest corner of South America, quite a ways from here. We're way up there on the top left-hand corner, of course. And here's a title page of the report itself with some more information about the authors. So I want to give a little bit of background about the report and a little bit of background about the topic. And then Dominique and Matías will dig more deeply into some parts of the report. And let me just start my timer so I don't talk too much. First of all, the current social and political context in Chile. As some of you know, what, I'm going to stop sharing this at the moment because it's going to be up there for a while. And I would like to just have a cleaner screen. As many of you will know, starting in October of 2019, There was a social explosion, estallido social in Chile that was unexpected to many people, not so unexpected to others, but it led to a prolonged social and political crisis in the fall of 2019 that eventually led to a political agreement in Congress to reform the Constitution, to pass a reform that would allow a deeper process of reforming and in fact writing a new Constitution. A new Constitution that had never been written in such a kind of a procedure in Chile before. There, I just want to briefly summarize a couple of the key components of the reform that was agreed to in November 2019. And I will say that a lot of the timetable, of course, has been messed up by COVID because the pandemic has hit Chile hard as it has hit many places hard. So some of the timeline has had to be adjusted. But the basic components of this political agreement were first to have a national plebiscite on the question of whether or not the Chilean people wanted a new constitution. And if so, how to write it. And that was held in October of 2020, last fall, and the answer was a resounding 78% in favor of writing a new constitution, and written by people who would all be popularly elected to the task of forming the Constitutional Convention that would write a new document. The election of those popular representatives to the convention hasn't yet happened. That's one of the things that's been delayed a few times. It's supposed to happen in May, ojalá. And if once the people are elected to the convention, they have a year to write a new constitution, after which there will be another plebiscite for people to vote on whether they accept or not the new constitution. There are two basic rules to understand about how the drafting process will work, although, as I say, we haven't got there yet in the calendar. The first is what's referred to as the hoja en blanco, which is a blank piece of paper or a blank slate. I've seen it translated. And that means that the people in the convention writing the new constitution are starting with a blank piece of paper. There is nothing on it. Anything that is going to go on the piece of paper has to be put on it. And this is the second rule. The second rule is that for any new rule to be put on the blank piece of paper, there has to be a 2/3 vote in agreement out of this 150 plus people in the convention. Those are the two basic rules. So of course, the people could decide to transfer over big parts of previous constitutions onto the blank sheet of paper, but until they've done that, there's nothing there. So that's a little bit of background. Now I want to say something about this project. And here I will actually go back to sharing my screen. Because I wanted to say some brief things about the different organizations involved in this process. This is a joint effort, this project between the Chile-California Conservation Exchange, which is named here, and also the Universidad Diego Portales in Chile. The Chile-California Conservation Exchange in turn is a program of the Chile-California Council, which is a nonprofit located in California. And obviously the topic of the organization is relations and collaboration between Chile and California. In recent years, this exchange has organized binational meetings about shared environmental issues, especially having to do with the coast. This year, partly driven by the pandemic and the fact that and the possibility of a constitutional reform and all of the other unexpected changes, the Conservation Exchange decided to try to, or had the idea emerged to get together a group of US and Chilean lawyers to talk about the public trust doctrine as a possible input to this new constitutional reform process in Chile. We'll get a little more into what that doctrine is, of course. I just want to say by way of introduction that the Universidad Diego Portales is one of the leading universities in Chile, and particularly the law school at that university stands out for its engagement in public interest law and public policy topics. And in fact, in being interested in going beyond the frontiers of a strictly policed notion of law. So to my mind, it's the most interesting law school in Chile, and therefore I've been collaborating with it for 20 years. Both Matías and Dominique are faculty there, although as I say, we have a number of authors from other law schools in Chile as well. Finally, the UDP has been an important partner because they are part of a group of organizations in Chile with money from the Ford Foundation to be facilitating in various ways public dialogue about the new constitution. And Dominique can talk more about that than I can if anyone's interested. So that gives you some idea of who were the two players here. The process that we followed was essentially a lot of Zoom meetings. There were a group of US environmental lawyers, mostly law professors, and a larger group of Chilean environmental lawyers, both law professors and also people working in environmental NGOs. And we had many meetings and back and forth production of drafts and conversation. The report was written in Spanish. The initial stage of this process was basically the US partners presenting the public trust doctrine, which is essentially a US legal creation, at least for our purposes today. And then the Chilean team absorbed that and sort of took it over and wrote a report making use of it, but trying to adapt it to the Chilean legal reality. So the final point that I want to highlight about the introduction here is that this was really a project in comparative law, in lawyers and legal professionals, mostly in two different countries from quite different legal systems, as many of you will know. That this common law tradition in the US and the civil law tradition in Latin America and Chile are quite different in important ways. And so the real topic throughout this project was how to bridge that gap, both in translating the language and in trying to understand the pros and cons of the different legal systems. Okay, how am I doing for time? I'm okay for the moment. I'm just going to pass on now to my next slide. This is background. I want to give background because I know there's a range of people here listening, some of whom will know this quite well and others maybe not at all. So I want to briefly give some background that is not in the report about the constitutional context of the 20th century in Chile, and also the 1980 constitution that is now being reformed or being rewritten. The key point here, the importance that people need to recognize about the 1980 constitution is that it was intended to be, it was written by the military government and it was intended by that government to be its fundamental legacy after 16 plus years of deep transformation of Chilean society. It is obviously a highly political document, but the point is to understand the deep institutional importance and the rules that were set out in that document, and also to understand the symbolic and emotional importance that the document has for people in Chile, both pro and con. That's necessary to know. And of course, I have no time to go through the timeline of the 20th century here on the screen. The only message here really is to say what it was that the military was reacting against when they wrote this constitution. Essentially, they were reacting against the previous half century of the 20th century. The previous constitution had been passed in 1925. It was a sort of a standard bourgeois parliamentary democracy that allowed for the growth of the modern administrative and welfare state and developmental state in Chile, starting in the 20s, 30s, 40s, 50s. In the 1960s and 70s, the growth of the state, as well as the level of social dynamism and conflict and demand for reform in Chile, as in most other countries, kept on increasing to an ever greater degree. Finally, in the early 70s, reached a culmination in the sort of leftward swing of government that was eventually met with a military coup. Now, I know there are many different opinions about all of these events, and I hope you don't mind me summarizing them so brutally. My point there is that when the military took power and kept power, and they chose to be ambitious in the kinds of deep changes they wanted to make in Chilean society. And therefore, when they wrote a constitution in the middle of their term there, as you can see in 1980, it was an extremely ambitious document, trying to boil down all of the deep changes they were making into institutions that would be locked into place even after the military left government. And that is indeed what happened. You'll see at the very bottom, in 1990, there was a transition to democracy. And a series of governments, all of the same coalition, all of which, however, agreed to respect the rules of the 1980 Constitution as part of the political agreement for the transition back to democracy. So as you can see, no matter what side of the political spectrum you might be on, this is an extremely important document. Finally, there were two important reforms that have already been made to this document. One was in 1989, which, as you can see, is just at the end of the military regime and just before they handed over power to the new civilian regime. And then there was another packet of reforms in 2005, which, as you can see, was basically in the third of those three successive governments. These were significant reforms in various ways. However, what they all addressed was the political and not the economic aspects of the Constitution. And that's the point that I want to turn to next. If I can find my next screen. So, and now I want to just briefly highlight some key features of this 1980 Constitution. In the first place, and I think most important, are the political features. The Constitution is well known to comparative political scientists, for example, as an example of an authoritarian, anti-democratic constitution, typical of some in Latin America in this period of time. There are many interlocking political provisions, and I don't want to get lost in trying to explain them all. The basic point is that this Constitution gives great authority to the president, to the executive branch, and the counterbalance is not from an elected, a strong elected parliament, but rather to various technical and supposedly non-political organizations. This is the original scheme back in 1980. As I say, some of these features have subsequently been moderated. The bottom line of all of these bullet points about politics is that the room to move for democratic government is quite limited. And there are various different rules that interlock and that reinforce each other, such that changing this legal document is extremely difficult. Mostly these political aspects are what people have paid attention to, both in Chile and in other countries. However, as you see in the bottom part of the screen, in my view, one of the most important features of the Constitution are its economic provisions. There are not many of them, but they are important and powerful, and they add up to the well-known neoliberal focus of the economists who were working with the military regime. So a few but strong declarations of strong private property rights, strong and broad private economic liberties, tight restrictions on what the state can do as an economic, in terms of economic production or enterprise, and also in terms of economic regulation, a new role of the judiciary as a way to control any future excesses of the state. So basically it's a small part, it's referred to as the public economic order, as you see there. It's a small part measured in terms of the number of articles in the Constitution, but it's a hard core of neoliberal economics. And it hasn't been touched in any of these previous rounds of constitutional reform. Finally, environment is mentioned, as my colleagues will talk about more. And it was innovative in its way to be mentioned in 1980, although, as we'll see, it's weaker than some of these other rights. And now, the broader message here then, in terms of environment, which is what this report is focused on, is that because private property and other economic rights are so strongly locked in and protected, it is extremely difficult. It has already proven extremely difficult to increase government regulation over private property rights for environmental purposes or for other purposes. Under the previous constitution, under the 1980 Constitution, that sort of deadlock is built in, and I think everyone is used to it. But the possibility now to write a different kind of constitution means that this is opening up as a possibility in a way that it hadn't for decades. So I'm just about to finish here with my comments. This is the table of contents of the report itself. I've just robbed a few pieces of chapter 1 here of part 1. Part 2 about the public trust doctrine is mostly focused on the US because that's the origin of the doctrine here. We're going to spend less time on that here because the purpose really of this report was to try to adapt this doctrine to the different reality of Chile. So it's parts 3 and 4 and the conclusions that we'll spend more of our time on today. I think I will stop sharing. I am okay with time. I guess maybe I guess I should just stop. I shouldn't ask for questions. That would mess things up. I'm just going to stop right there and pass it over to Matías Guiloff. Thank you very much.
Hey, I will share my screen. And first of all, I must say that it's quite honored and for the opportunity of being with you this evening at the University of Arizona. I'm actually a graduate student of the University of Arizona. I did my doctoral degree there, so it's nice to be here virtually speaking. And having said that, what I will talk before passing it to Dominique is two things that are that the report deals with, and that are important in order to understand the report's proposal that will be explained by Dominique. These two issues I want to deal with are, first, what is the public trust doctrine? And next, I would like to explain how does this doctrine fits with Chilean law? In other words, why are we proposing to use this doctrine in Chilean law? So since we don't have much time, let's start addressing the first one right now. As to the public trust doctrine, very briefly speaking, you understand that this is not the moment like to give a very detailed explanation about this legal concept. The public trust doctrine is an historical legal concept, the origins of which are traceable to Roman law and the English Carta Magna. At its core, this doctrine holds that the government is bound to the obligation to manage and protect certain elements of nature for the public's benefit. Which elements are these that the government must manage and protect for the public's benefit? This is quite important. Traditionally, it has been argued that those elements were navigable waters and the seashores. But nowadays, these elements have been expanded. They also include lakes, wetlands, fishes, wildlife, and water, including subterranean waters and ecosystem services. A next thing that it's important to consider is how does this doctrine, the public trust doctrine, is related to other instruments which the government can use to protect the environment. Perhaps the first of these instruments that comes to mind is the police power. So how can the public trust doctrine can be compared with the police power? It can be argued that as opposed to this police power, the public trust doctrine is stronger, as it not only provides the government the authority to protect these resources, but imposes a duty on the government to do so. In other words, the police power only provides an explanation, a defense that the government can use whenever issuing regulations or enacting laws to protect the environment. Whereas the public trust doctrine is not a justification, it's a duty, and therefore something that both legislators and administrative agencies must comply with permanently. In practical terms, the public trust doctrine aids in preventing private monopolies and governmental giveaways of these resources. It operates either as a doctrine on which courts can rely when deciding cases, or as a rule codified in some states' constitutions, statutes, and regulations. I will say much more on these different implementation alternatives very soon, because this is very important for the purposes of our report. Concerning the most known cases, or as you say in the US, the landmark public trust doctrine cases, these are the Illinois Central Railroad case and the Mono Lake case. The Illinois Central Railroad case, it's a case from the 19th century that was ruled by the US Supreme Court, and the ruling issued in that case established that the state of Illinois did not possess the authority to grant fee title to submerged lands held in the public trust as navigable waters. In other words, the government does not possess the authority to give to give resources held in public trust to private parties. As for the Monolake case, the court held that the public trust doctrine restricts the amount of water that can be withdrawn from navigable waterways. As mentioned before, this is one implementation alternative for the public trust doctrine as a doctrine that can be used by courts. But there is another implementation alternative, which as I shall later explain, fits much more with the characteristics of Chilean law. This implementation alternative is by codifying the doctrine in legal text, constitutions, statutes, and regulations. And this implementation alternative has been used in the US, specifically in the Pennsylvania and the Hawaiian Constitution, where there is a rule that codifies the public trust doctrine. For instance, the Article 1, Section 27 of Pennsylvania's Constitution provides that the states requires the state to conserve and maintain public natural resources for the benefit of all the people. As for the Hawaiian Constitution, Article 11, Section 1 stresses that all public natural resources, including land, water, air, minerals, and energy sources, are held in trust by the state for the benefit of the people, and the state must conserve and protect these resources. Having explained what is the public trust doctrine and which has been its development in the US so far, let's now deal with how does this doctrine fits with Chilean law. Considering the characteristics of the Chilean legal system, which as opposed to the one of the US is much more statute-based, relies much more on legal texts rather than on rulings by courts. It's, in other words, or in more technical legal words, it's a continental legal system based on the continental tradition in which case rulings have not a binding effect as they do have in the US. So, given these traits of the Chilean legal system, it is important to bear in mind the distinction between the content of the public trust doctrine. As I said before, this content is the duty to protect certain resources and its implementation means. As for its content, the public trust doctrine closely resembles two institutions recognized by Chilean law. The first of these institutions is the National Goods for the Public Use doctrine. This is a translation of Bienes Nacionales de Uso Público. The second of this doctrine is private property's social function clause contained in the Chilean Constitution. As for the first of these doctrines, it imposes a duty on the government to manage certain resources, such as inter alia, water and seizures, for a certain purpose, thereby impeding their private appropriation. However, and this purpose I think it's better if I explicitly say them, these purposes are that they can be used by all the public. And that is why this impedes their private appropriation. However, this doctrine is not recognized, at least directly, in the Chilean Constitution. This is important, for it entails that the Constitution imposes no duty on the government to manage and protect these resources for the public benefit. Moreover, and contrastingly, as the Constitution does protect with the right to private property water rights granted by the government, water has been in practical terms converted to a private good. Concerning the second of this institution, private property social function clause, it provides the legislature a defense for the regulation of private property rights. As you can see, private property social function clause, it's somehow akin to the US police power. It's a defense for the government or for the legislature to regulate private property rights. More specifically, this is a defense for regulating property rights without the need to pay compensation to affected parties. To understand this, it is important to consider that as opposed to the US Constitution, the Chilean not only addresses the taking of property, but also the governmental power for its regulation, which is grounded precisely on this clause, because the US Constitution does not explicitly regulate or does not explicitly deals with the police power. It's a doctrine that has been used and since a long time. But in Chile, there is a clause in the Constitution that explicitly regulates and establishes the conditions for using this, private property social function clause. Yet, as mentioned, this clause only provides the legislature with a defense for those environmental regulations that it decides to enact, but it does not impose an affirmative duty on such body to issue such regulations. So, therefore, and I'm finishing right now before passing to Dominique, as for the public trust doctrine's fitness with Chilean law, one can argue that there is a gap in the current Chilean constitutional framework concerning the protection of the environment and natural resources, as neither of the aforementioned doctrines establishes the state's duty to protect these resources. The ongoing constitutional process affords a unique chance to fill this gap, and for these purposes, the Hawaiian and Pennsylvanian constitutional public trust clauses show how can this be done. Now, I will stop talking and leave you with Dominique.
There. Now I can talk. Thank you, Matías, and also thank you to Carl for this invitation. It's a very interesting opportunity for us to be here and discuss this report and this work we have done for the last months with the public interested in discussing these issues. I can also say that this process of writing this report was very interesting. The fact that 20 academics, legal academics, were meeting permanently for so many months was really very interesting and also very demanding, as it is hard to get consensus on what we really want to say. And I think at the end of my presentation, you will see that still we are discussing some precisions to our proposal. So it will be interesting to talk about it as well, I think, now, because we can see that this report is alive and that we have to still continue discussing this issue, which is very, I think, a very interesting and good proposal for our new constitution in Chile. So I will talk about what we discussed about the implementation of the public trust doctrine in Chile. And our reasoning was that, as Matías said, we need a clause that imposes an active duty on the state to act. So we analyzed that this could be implemented either by the legislature, by the executive, or by the judiciary powers. And to decide which was the best way, we analyzed and compared the differences between these powers in the US system and in the Chilean system. As you know, the public trust doctrine in the US was basically developed by the judiciary, and that obviously comes along with the legal system in the US, which is a common law system, and which is very different to our own legal system, which is a civil law system. So I will talk about the reasoning we did, but the conclusion we got to is that in Chile, there is an opportunity to implement this doctrine through the new constitution. So what was the comparison we made about legislature in Chile and in the US? I will talk about the characteristics of the Chilean legislature, which in a way we found that it was not so different in some aspects with the US powers, but some characteristics make it important in Chile to decide that the best way was to go through the constitutional clause. So the legislature in Chile is slow to address social problems, and it has been our experience for the last years and decades that health problems, environmental problems, labor problems are very slow to be addressed by the legislature in Chile. And that is because, in part, there are some constitutional restrictions to legislate. For example, there's a requirement for high quorums to regulate in the Congress. Also, there is a concentration of authority to initiate legislation in the executive power. Also, I think most important, there is a constant threat of the intervention of the Constitutional Court, which has traditionally interpreted very narrowly what is allowed to regulate by the Congress and also by the executive branch of the state. So also the legislature in Chile legislates through framework laws that need additional administrative supplementation. We saw that specifically in the environmental framework law, which needed, when it was enacted, which needed many administrative regulations to be fully implemented. So we thought that this a general constitution clause like the one we have now in the Chilean constitution will not be easily implemented by Chilean legislature. So there is a need to establish a constitutional standard that is sufficient in the absence of legislature that will enact this provision. About the administration and the executive branch, it's very evident that I think we all agreed in that the executive branch in Chile is very limited in order to be able to enact regulation, because it has several restrictions in its power to regulate, specifically this doctrine of the legal reservation. That means that many issues have to be regulated by law. Also the Constitutional Court, which has said several times that regulations enacted by the government are unconstitutional. And also, and not less, regulatory agencies in Chile are weaker than in the US, in the sense that they depend much on the presidency, and there is a lot of political influence and not a very strong public service career. So technically, and it's a weaker, I would say, and we are all said that, a weaker branch than what a regulatory agency could be in the US. So a public trust provision in the Constitution would probably strengthen regulatory agencies as long as it is clear that public administration can develop it through its regulatory power. Then we talked about the judiciary, both in Chile and the US. In Chile, there is a system of specialized courts of first instance with jurisdiction over certain areas such as labor, family, tax, environment. And there is a Supreme Court at the top with jurisdiction over the entire national territory and that can review judgments, revoke them, and replace them. Also, as I have mentioned before, there's a constitutional court which has a very different jurisdiction from the Supreme Court. And we have this civil law system compared to the US common law, where precedence is a doctrine. In Chile, we don't have the precedent doctrine. Therefore, judiciary interpretations are not necessarily consistent. And it's hard for courts to develop doctrines as they do in the US. We have environmental courts, and I think there have been a very interesting new institution in Chile with many positive possibilities, but still there's a limited jurisdiction over certain environmental matters and with limited access by citizens to claim their rights in these environmental courts. So we think that judiciary is not really the place to develop this kind of doctrine or this kind of duty of the state, even though environmental courts could play an important role in the enforcement of a constitutional clause endorsing the public trust doctrine, in the sense that the state will have an active duty to protect nature, and then environmental courts could help enforce this public duty, active duty of the state. So finally, we thought that the best means to implement the public trust doctrine in Chile is through a constitutional clause for the protection of nature. And it is important that this clause specifically establish a duty that binds the government and is enforceable by citizens. We still are discussing the precise wording or phrasing of the clause that we consider we want to propose to include in the new constitution, but here is a possibility that we have thought to include, to propose. So this constitutional clause for the protection of nature that is inspired in the public trust doctrine should, first, establish a duty on the part of the state and its subordinate agencies to protect nature, including the integrity of ecosystems for the benefit of the public, including future generations. Second, provide that when it is in the public interest to allow the private appropriation of natural resources, the state has a duty to assure that such private use does not substantially diminish public rights and is in the public interest. And three, enable citizens to enforce the public trust in courts and administrative agencies. We have discussed about where to include the citizen enforcement part of the clause. And I think we are not all agreeing in the same possibility, that is to include this clause in the public trust clause specifically. But there's another possibility that you could include it in a more general provision regarding environmental citizen enforcement. So I think either way, I think we all agree that citizen enforcement should be included regarding the duty of the state to protect nature. So I think I will stop here. I hope I spoke clearly enough, so we can now discuss the content of this proposal with all of you.
Wonderful. Thank you so much for those three terrific presentations. So I will be happy to field questions from the audience that you can address toward any of the speakers or all of them in general, and they can respond as they see fit. And I have a couple of questions in the chat, so you can put any questions you have in the chat or comments, or you can also use the raise hand function, and I'll try my best to keep track of the order if we start to create a line. But why don't I get us started with some of the questions in the chat. Actually, our first question is coming from the director of the Center for Latin American Studies, Professor Marcela Vasquez. And she has a question particularly for Matías about asking about the multicultural turn, which was adopted in several Latin American constitutions in the early 1990s, with important environmental implications in theory, not necessarily in practice, of course. And so she asked, did the 2005 Constitution incorporate anything on Indigenous, territorial, and collective rights? Or I suppose if others feel like they'd like to speak to that question as well, they
can. I think I'm not specialized on Indigenous rights, so maybe Dominique can add to what I will say, but specifically, I mean, the 2005 amendment did not include nothing on Indigenous peoples, and that's precisely one of the main issues that we are discussing on this constitutional process. And not only concerning the environment, I mean, it's a huge political issue in Chile, the situation of Indigenous people. So aside the environmental implications for the resources and the use of resources by Indigenous peoples, there is a discussion that has not been addressed so far as to their political status that has been avoided. So that's what I could say about that. I don't know, Dominique, if you want to add something to this.
No, I agree with you. The Constitution has not included anything about Indigenous people's rights, even though we have international convention, the ILO 169, which is being implemented directly by the courts. So there we have probably a judiciary more active in certain issues, which has not been the rule for, I would say, for the judiciary in Chile. But in this case, the judiciary has been very important to promote Indigenous rights in Chile. And I think it will be, I'm sure it will be part of the new constitution. I can't think of a new constitution without this new recognition of Indigenous people's rights. It depends how, but I think it will be recognized in a way.
Okay, great. Thank you so much. So we have a bunch of questions in the chat, so I'll just keep reading them off. But most of them are, if you want to read them along with me yourself, most of them are available to everyone. So we have a message from, or question from Liz Kirkwood, directed at the entire panel, asking whether you've considered extending the public trust doctrine to groundwater as part of a proposed constitutional amendment.
Who wants to say that, to answer that? I think
I'll start. Go ahead.
I would say that we were thinking of a very broad public trust clause to be included in the Constitution, which includes nature in general. So it would be included, I would say, in what we have discussed. But there have been some other opinions as well. Maybe, Carl, you can elaborate on that.
Well, I guess I would add that we very carefully did not get into water rights deeply in this report because it's complicated and a whole other story. It is a very hot topic in terms of the new Constitution. So we certainly intend to relate the public trust doctrine to water rights, but we didn't really want to We didn't take that on. We didn't propose a clause about what should happen with water rights in the Constitution. I think that will flow from what we can go there from this work, or some of us can. But I think certainly the idea would be anything that is said to change the definition of water rights would include groundwater just as much as surface water, I think.
So great, thank you. So the next question is coming from Sonia Ziaja. Sorry if I said that name wrong. Could the speakers relate any of the arguments regarding where to include the citizen enforcement provision? Also, has the group discussed whether to include a fee shifting provision, allowing attorneys representing citizen suits for the public trust to be paid if the suit succeeds?
Who wants to answer?
Maybe Matías, you can talk about the possibility of including enforcement in other provisions of the Constitution and why.
This is this question has two complexities. I think it's better to describe such complexities rather than giving a definitive answer to this question. First complexity is one dealing with the legal tradition we have been describing. No, I mean it's Chilean legal tradition consists mostly on doing things by statutes, by legal texts. I mean, judges are not the main protagonists, the main actors or actresses in the legal story in Chile. So first of all, you have this kind of traditional objection. Of course, it's a tradition; it can be changed, but as a tradition, it has kind of a hold on these discussions. And secondly, leaving aside that issue, there is the more specific textual issue dealing with where you would exactly want to put this kind of enforcement provision in the Constitution. I mean, would you like to put it in the public trust clause that concerns natural resources, or following the path that was established in the 1980 Constitution, you would put it in the provision dealing with the right to deal with an unpolluted environment? I mean, those are two issues you would like to consider as to such a proposal. And as for the specific question, I would say that just as Carl replied concerning groundwater, the protection of groundwater, in the report we try to be to not deal with these specificities because we want to open the discussion. We want to open the discussion, and this is kind of a very specific implementation mean. So we're not close to it. I mean, we're not saying no, but it's something that we have not been studying in detail, and I think it's something that has to be discussed during the convention with other possible implementation alternatives that can be useful for this purpose.
Okay, great, thank you. So we're getting a lot of great questions. Thank you, everyone. So the next question is coming from Claire Beer. She thanks you all for a wonderful presentation. The existing gap in the Chilean Constitution regarding a public trust duty, how does Article 19 articulate with this?
Who wants to? Article 19 currently is the article that lists rights, individual rights. There are a lot of numbers. It's number 24 that has to do with property, but actually numbers 23 also has to do with property. When I talked about the public economic order earlier in my talk, really that's Article 19 and about 3 or 4 of the paragraphs within Article 19 and a couple of other parts of the Constitution. So if the question is, Article 19, paragraph 8, right? That's what, as Matías was saying, that's one of the places where environment is mentioned. That's where it says that everyone has a right to live in an environment free of contamination. Dominique maybe could say more about what has been the weakness, or what do you think have been the pros and cons of that environment clause, maybe number 8, numero 8?
Yes, well, this, as Carl said, it's considered an individual right. So to claim this right, you have to be directly affected. So in your own living environment. So it's not a collective right. It's not there's no possibility to claim for the protection of the environment if you are not included in the affection directly. And so I think the public trust is related with this right, but it's broader than that. So I would say it is not merely a right for persons, it's also a duty of the state. And in that sense, it also relates with the public interest in the management of natural resources, which doesn't have to do with your own environmental right.
And may I add something? I guess this is very interesting, you know, because even though we have this Article 19, number 8, we have this gap because that's because of something that goes beyond the legal text, you know. Legal texts have the interpretation they have because of the culture that interprets them. And in Chile, interestingly enough, and very important for the purposes of this report, there is kind of a stark contrast between, an artificial, I would say, between the constitutional protection of the environment and the constitutional protection of natural resources. Dominique has wrote about that. I mean, whenever you study the protection of the environment and natural resources in Chile, you say there are 2 groups of provisions, one concerning the environment, another concerning natural resources. And this, of course, this division is kind of artificial, but the thing is that as for natural resources, the group of provisions concerning natural resources only address these resources from the perspective of private property rights to use them and to exploit them. So that explains precisely why do we need a public trust clause in the Chilean constitution to end this artificial divide that has been reinforced by the legal culture that has interpreted the 1980 constitution.
Great. Well, I think like as the moderator, I'm going to take advantage of my power and sort of ask a like more detailed follow-up question to this one in particular. I was curious. So in that clause you were talking about, when it was interesting how you phrased it as an important difference between individual right versus a collective right. But I'm curious in how it's framed as like the right to live in an uncontaminated environment, and was curious like what were the sort of metrics or legal mechanisms that people would have to, you know, it sounds like very, you know, familiar language in terms of creating a very difficult situation for someone to prove that they live in a contaminated environment, and through what mechanisms, what metrics, and then of course the amount of resources necessary to actually make some sort of, you know, biocitizenship like claim. So if anyone wants to add a little bit more detail, and then how that might shift if it was a collective rights claim to an uncontaminated environment.
Well, I would say that even though it's easy to claim this right because you can go directly to the appeals court and claim that you have been, your own right to live in an uncontaminated environment has been violated. So it is quite easy to claim. It's not that you need to prove many, of course you have to prove, but it's not so technically necessary to prove the unpolluted environment. You have to prove that you have been directly affected, or that your own rights, individual rights, have been affected by this pollution of the environment. So it's not the same than an action or a judicial action to claim for the pollution of the environment in general, for example. No, you have to be affected in your own rights, and you have to prove that. So you have to be a single person that has to be affected and to claim this violation of this right. And this is quite different, as Matías said, from the state duties to determine the use of nature, you know, and there citizens don't have any action to claim for these decisions, public decisions. So I would say that citizen enforcement related to public trust would be very interesting and very new in Chile, because people would be, or citizens would be able to claim if, for example, the state grants a concession for the use of a certain natural resource in a certain way, which citizens consider that is not going, it's not going with the public interest, for example. So that kind of action does not exist now in the Constitution.
And also, I would say the right to environment is of a lower hierarchy than the economic rights that we mentioned earlier.
Great, thank you. So our next question is, although Marcela, I see your hand. Do you want to ask a follow-up, or do you want to be in line?
I'll ask a quick question. Thank you very much for a great panel. I do have a question that is related to this issue of the right to have or to live in an uncontaminated environment. And it has to do with the zonas de sacrificio that the government declared, sort of justifying that we have these citizens that live in highly contaminated areas, but they sacrifice themselves for, I guess, the good of the nation, right? Especially in areas where there are several thermoelectric plants. So I don't know, because these are citizens that are demanding collective rights to live in an unpolluted, or not, or at least not in a zona de sacrificio. I don't know if you can say something about that.
Well, yes, I think these cases of zonas de sacrificio, which are not legally declared, it's a term that is used in Chile, no, to make evident some situations of certain local populations who are being grossly impacted by environmental pollution. And therefore, the Constitution, I would say, does not include, for example, an action for citizens to enforce their collective right to live in a clean environment. For example, in these cases, citizens have to add their names in an action in order to be able to claim for their collective right, because it's an addition of individual rights. It's not a collective right per se. That's what I would say. And even though I think the public trust doctrine does not really relate directly to this issue, it may the incorporation of a citizen enforcement clause in the Constitution would help these citizens to claim for their own rights. I don't know if Matías, you want to say something else about it.
I tend to agree with Dominique's analysis. I mean, of course, having a citizen suit provision in the Constitution would, one would reasonably think that when having such provision, that would translate into having more enforcement or more possibilities of enforcement, more chances of enforcement. And if there is more chance of enforcing, then it's more possible that the administrative agencies will have a reason for acting for this and for protecting and issuing regulations that protect this zonas de sacrificios. I mean, this is, I think, what explains why in the US, I mean, since the late 80s, there was a campaign against citizen suit provisions, and why there is so much resistance over the world to citizen suit enforcement provisions. So yeah, I would think that it's quite reasonable to think that with a citizen suit enforcement provision, one could have a more governmental action concerning zona de sacrificio.
Can I just interject here? I wanted to make a couple of comments. One, in general, one thing that I think both Dominique and Matías are talking about, I mean, if you remember the final slide of Dominique's when she showed it was the third clause at the end of our proposed text, that's when we mentioned something about citizen enforcement. The reason that we're going around in circles about it is none of us disagree about citizen enforcement. When I say us, I mean both the gringos and the Chileans, right? We all think that citizen enforcement is important, but there's been a theme throughout this whole project, which is how do we make sure that we don't just put laws on paper? How do we make sure that anything we do is going to really work? And if citizen enforcement isn't going to work, then we need to rethink it. And we know that we can't have the assumptions in Chile that there will be a bunch of judges ready to enforce. So it sent us through a lot of loops about, okay, what other institutions can we put the burden on? And so it's, I mean, when I was saying this was an exercise in comparative law, that's partly what I meant, that trying to figure out what, how can we get these words from one country to another, but then translate it into institutions that are actually functioning there. The other point I wanted to make is that our view of the public trust doctrine, and in this we drew a lot on one of the other US lawyers who I don't know if he's on this call, but Mike Blum is one of the principal co-authors. It's really important to us to clarify that the public trust doctrine is not about attacking private property. The public trust doctrine is about somehow accommodating and balancing and combining public and private rights to public resources. So it's a sort of a deeply pragmatic question in some way. There's obviously some core principles involved in it. But we're trying to be careful, and how would this be a doctrine that can be used in sorting out property conflicts rather than just some sort of big regulatory hammer, which will probably not get through. That was merely more of my editorial comment there. I don't know if my colleagues would agree to it, but I just wanted to flesh out a little more about what we understand by the public trust doctrine and how it relates to both public and private property.
So next we have a question that if this feels redundant, if certain questions feel redundant, feel free to be like, I think we've already addressed that because we have a lot of questions. So, but it's hard for me to sort of keep track of whether someone's asking a more nuanced question or whether it's already been sort of answered. So, so Sarah Dannenbrink asks, how would citizens be enabled through the PTD to enforce in practical terms the public trust in courts and administrative agencies? I was also sort of interested in what it sort of signifies also to put the burden on the citizen to be the one who does the enforcing. But I
think that's what we're saying. That's what I was just trying to say. This is what we're going around and around about. We're not sure how to spell that out.
Yeah. Okay. So next we have a question from Rodrigo Valdez Pineda, asking if one of the presenters mentioned that the report was exclusively made by water law experts. My question is, do you think the construction and development of a more environmental water law should consider the opinion of local or regional water users and managers or other water experts such as hydrologists or hydroecologists, all of them who might provide a broader or more specific view of the water environment related conflicts? Do you think more specific aspects should be considered in the construction of a new water law for Chile?
Can I just jump right in and say, and just repeat again, we didn't really deal with water rights in this report.
Okay.
I mean, water rights are probably the most important example of a bien nacional de uso público, right? Of a public property to which there are private use rights. So it's right at the heart of all of these topics, but we did not get into the weeds of water rights. And I would prefer not to go there myself today.
Okay. Oh, sorry, Rodrigo, I now see that you pasted it below as well. So hopefully the original question still got it, what you were asking. So I'll move on to the question from Miguel Solanes. This is another one about water, maybe. So I'm trying to see. Yeah, I'm sorry. I think we're gonna. Yeah, well, let's skip past that one since we've kind of, sorry, I'm not reading them before I say them out loud. There's more about water rights. So I'm going to jump for now since we're running, still have some time, but don't want to run over. So I'm going to jump to James Sheldon's question. Do the authors or the report sponsors have a strategy for promoting the findings of the report in the drafting process that will start after the election of the 150 plus constitutional representatives?
Matías Alcalde answered that in this.
Oh, sorry.
The chat. So maybe.
But yes, but that's why we're here today. We're here today because this is the kind of public event we'd like to do more of.
Okay. Okay, so moving on to Christiane Perez. The constitutionalization of PTD in the US, for example, in Pennsylvania, dates back to 1971 and applies to states individually. And there is not one single way to interpret the extent of its application within the many states of the Union, especially with respect to environmental conservation. Why would it be advisable that Chile as a nation adopts a doctrine that is so heterogeneously applied not only within the US, but also in other countries? Shouldn't the proposal elaborate also on the reasons why there is such differences of opinion about PTD cons? Shouldn't we consider new mechanisms like transferable development rights to redistribute the rights of development instead, to protect high conservation value areas using incentives as mechanisms, i.e. Central Park, Hudson Yards, and NYC, as opposed to introducing constitutional limitations? TDRs were already included within the Bill of Law delivered by President Bachelet in 2007. Anyone want to? I know it's a long one, so.
I mean, I'll try to answer part of it.
Okay.
The point of suggesting Hawaii and Pennsylvania is because those are examples of a sovereign, a state, not a nation, of a sovereign defining the public trust doctrine for their constitution. It's just a possible text to decide to use or not in the Chilean case. Clearly, well, I would say two things more in response. Clearly, there's a lot of different interpretation of the public trust doctrine all over the place in the US and elsewhere. So, I mean, I don't know that that's a reason not to explore it, but it's obviously true. I happen to agree with your critique that we didn't spend a lot of time in this report criticizing the public trust doctrine. Some of us are well aware of some of the critiques of the doctrine. And actually, that's partly why I made the point a few minutes ago that the public trust doctrine is about balancing public and private rights, not about attacking private rights. I don't want to go further down the rabbit hole there. I don't know if anyone wants to join me, Matías or Dominique, you want to add anything?
Perhaps the only thing I could add to that is that, yeah, one of the main criticisms to the public trust doctrine is kind of that it's where does this come from, that it's not quite determined, but if you read carefully our proposal, we kind of deal with that because we're proposing, we're not just trying to copy the public trust doctrine that has been used in the US and paste it in the Chilean context. The main task, all of our discussions, we spent a lot of time looking at those kind of differences between Chile and the US in order to make a proposal that is inspired on the public trust doctrine, but it's not exactly the US public trust doctrine. So I would say that we've been aware of those critiques to which the public trust doctrine has been subject. And that's why we are kind of proposing a strategy that concerns codifying the public trust doctrine. And that is why also precisely we have all these discussions and we are not very specific as to implementation means, and why we have been distinguishing all the time between the content of the doctrine and its implementation means. I mean, precisely for not being blamed for those indeterminacies that the doctrine is blamed for in the US. So my reply is that we are kind of doing a proposal that, as I hope we've demonstrated, is quite necessary, for there is a gap in Chilean constitutional law concerning the protection of natural resources. And this proposal is inspired on the public trust doctrine, but it's not exactly the US public trust doctrine.
Great, thank you. Miguel, did you want to ask a follow-up or?
Can I add something?
Oh yes, please, Dominique, go ahead.
Yes, I would like to add to what Matías and Carl have said, that it's not the same public trust doctrine, but what we think comes from the public trust doctrine is this active duty of the state to protect nature. And we think that this is not included in Chilean environmental law or environmental constitutional law. And we think it would be an improvement for the protection of the environment and nature to include this clause in the Constitution. But that doesn't mean, as Carl said, that there are other mechanisms that can also be included and considered in this process of improving environmental protection in Chile. So I wouldn't say that the public trust doctrine would limit other possible mechanisms to be included.
Miguel, did you want to add anything, or is that a sufficient answer? Sorry, he was writing in private chat that he would clarify. But perhaps we'll just move on then. Next we have a question from Rodrigo Ropert.
Yeah.
Oh, Miguel, did you?
Yeah. Can I simplify my question and explain it? Because it seems that it is too long as written, but I would like to simplify it and explain why I'm making it. Is it possible?
Please, Miguel, please, yes.
Okay, well, the question is, I personally have no objection. I think it would be an advancement to have a specific provision protecting or on behalf of the public trust. But at the same time, it would be, in my view, necessary, if you have this kind of provision, to have another balancing provision in some way related to what you just said, Carl, addressing the issue of the public interest related to water in the Chilean social system. If you do it in terms of protection of water rights as an alternative, there might be other possible options to address the question of the importance of water for economic and social purposes in the Chilean society. My concern is that if in a future constitution, you leave only a provision for the public trust intended to protect, let's say, only environmental values or natural resources value, et cetera, future interpretations in courts might create an imbalance between environment and the public interest in the economic role of water in society. However you want to frame this economic role and granting that the present system of water rights is not the very best you can have. But I really worry that a single provision related to the public trust without any provision addressing the question of the public interest in the economic and social roles of water, and social much beyond providing water for drinking purposes, might create a very, very serious imbalance, and in the long term be damaging, could have the potential to damage, let's say, the social fabric of the country. Basically, what I'm suggesting, you have to have a balanced set of provisions addressing environmental and economic issues if you want to prevent any kind of upheaval in the economics, not just of water, but in the economics of the country. Thank you very much, Stephanie, and thank you, Carl.
I don't disagree with that myself. I think the point of the public trust doctrine to me is, as I said a couple of times, it's how do you balance public and private? And so I think that, anyway, I myself agree that the public trust doctrine is not going to get rid of the water rights system, right? There's still going to be, in my view, there's going to be some version of a property rights system to water, and it might not be all that different in a lot of ways from what there is today, with some major exceptions, perhaps. So I certainly wouldn't agree to the public trust doctrine replacing the need for some sort of a water rights system. That may be just my view, though.
Great. Well, I think there were a couple of more questions that we sort of skipped over because they seemed, I wasn't sure if they had already been covered in the presentation sufficiently. There's one from Rodrigo Rupert about, according to the US experience, what are the political and economic advantages and disadvantages of the PTD? And I wondered if there are any points you want to elaborate further on that. I mean, I was sort of wondering, has this system worked so well in the United States that it would want to be used as a model for Chile? I'm familiar with some of the environmental justice arguments in the United States that say sort of the legal mechanisms that exist in the United States for claiming community rights to clean and healthy environments has been pretty unsuccessful, particularly like the sort of tort mechanism for claiming compensation. I'm not an expert on the legal framework of it, but I was also similarly wondering if you want to elaborate anything in terms of.
I would say that among the US members of the team, there are some quite different views about how successful the public trust doctrine has been. I myself am willing to say publicly that I'm not a big fan in some respects. I think that it has some obvious political disadvantages, and it has some, anyway, there's a lot to say about it. And which is, again, goes back to our point that we are not pushing the model on Chile. We are well aware of some of the downsides of it. I think that the main advantage of it has been in certain states in the US, and starting with California, that it has allowed a rebalancing of property rights systems that have been heavily oriented toward private rights, a rebalancing so that some later recognized public rights can be imposed without requiring compensation. I think there haven't been many examples of it. And by that standard, it's not necessarily broadly adopted or successful. The Mono Lake case that Matías described is always the one that gets explained because it's the one that has the best rhetoric in it. But I guess I repeat that despite those, so I mean, I would say there's critique of the public trust doctrine in the US. I think the deeper problem is that it hasn't actually been implemented that much, with a few exceptions. So the critics don't need to be worried about too much of an overreach in practice, I would say. Now, I don't know if some of my US colleagues would agree with that, and some of them are on this call. Do you either, Dominique, Matías, do you want to save me from myself here?
The only thing that I would add to what Carl said, and maybe I'm repeating something that I said before, but it's important to repeat it, is that, I mean, where does this proposal come from? I mean, it's important to bear in mind the gap we identified and that I explained in my part of the talk. There is a gap in the Chilean legal system concerning the protection of natural resources. I mean, you have had in the last 25 years a development of an environmental framework of agencies to protect people from pollution and all that, but nothing like that has happened so far concerning the use of an exploitation of natural resources. And we have seen in the last 20 years, in the last 30, I would say, a lot of instances where there are governmental giveaways of public resources. I mean, some people one could arguably say that water rights could qualify as a giveaway, and of course, fishing rights, fishing quotas qualify as such giveaways. So there is a gap. And considering the characteristics of such a gap, we started to think, what kind of doctrine can be used to impose a duty on the government to protect resources, these resources, to not make giveaways of them? And then came the public trust, and we are refining the public trust and adapting it to some characteristics of the Chilean legal system to fulfill these purposes. But it's important to bear in mind that the most relevant thing here is the duty and what can we do to implement such a duty in a country that the legal system is as it is in Chile. That's the most important thing, I would say.
Great. Well, we have, we're almost out of time. There's a comment from Charles Lester that says to Carl that the work that he's been doing on public trust and sea level rise partly frames that the doctrine will necessarily become an important force for protecting public natural resources and access to the shoreline. This is because public lands will be our moving inland. I don't know if you want to respond to that, Charles. Carl.
No, thanks. I just want to say that Charles is one of the many collaborators who's listed on our title page. And when I referred to the past work of the Chile-California Conservation Exchange on coastal issues, Charles was involved in all of that. So thank you, Charles. I don't have any disagreement with what you said. Just glad to acknowledge your presence here.
Yeah, and then Miguel wanted to give another follow-up if time allows, and there's just barely a minute left, so I'm not sure whether we'll be opening up another can of worms, but if you like, we can either close it there or we can, do you want to have another moment?
Yeah, let Miguel talk.
Okay.
Oh, thank you very much, Bauer. You are very, very kind to your elders. Look, the reason for which I am concerned is that in the Argentinian constitution, I'm from Argentina, although I have been away for the last 50 years. Presently, I live in Chile. And is that there is a provision somehow calling for sustainable development for the well-being of the people and the use of natural resources and the environment, etc., etc. Recently, a court issued a decision based on an environmental argument by which it took away half of the water of the river, supplying water for irrigation hydroelectricity, water supply and sanitation, tourism, etc., etc., within an area where about 400,000 people live. The court based the decision on some environmental provisions within a larger and more comprehensive article in the Constitution. It didn't address any issues of economic importance, social importance, harm not just to property rights, harm to the well-being of the people by taking away the water rights that had been in use for about 100 years. Therefore, I'm very afraid that perhaps the Chilean courts would be much balanced than the Argentinian courts. I have no doubt about it. But if some sort of public trust provision is written in the Constitution, I would really sleep better if I know that there is something there, at least addressing not the water rights necessarily, but the economic importance and the social importance of the use of water for the Chilean society, drafted in some legal manner that allows it to be useful and usable. That was perhaps 4 months ago, I wouldn't have made this comment, but after reading that Argentinian case, I'm really alarmed that some judges might really do not understand the importance of water for the larger social and economic fabric. Thank you.
Well, we're a little over time, but do you want to make any quick comments or leave it there?
I would just want to say thank you for being our pilot experience in trying to explain this. We want to keep refining it. So all your comments are really welcome. Thanks.
Thanks. Well, unless Matías or Dominique want to add any final word, we can close this session out.
Thank you for the possibility of being with all of you guys this afternoon, and speaking for myself to do something again on the University of Arizona. So,
well, thanks all. Well, let's all join in thanking all of our panelists for their fascinating discussion and engaging with all of these questions. We really appreciate you being here, and hopefully we will be able to see you in person at some point. But we're very grateful that you were able to join us online, and wishing you all the best. And thank you for, we had a great showing today. Thank you everyone for coming. We will hopefully, I'm sure there's other events where we'll cross paths, but we'll look forward to seeing you in the fall for the new Center for Latin American Studies Charla con Café series, hopefully with coffee finally again, or not just our own coffee. So yeah, and if the panelists, if you want to, you can stay on if you want to just say bye, but also if you need to get going, that's okay.
I just want to thank you all, and please keep us posted to see what happens with this. We would really like to have a second round to see how was this received in Chile, and if there are possibilities of seriously, impacting the new constitution. So thank you very much on behalf of everyone at the center and the university. Thanks a lot.
Thanks, Marcela.